Your Honor, this is the second call in Commonwealth versus David Hussey. All parties are present in the courtroom.
All right. Now, Ms. Fowle, you said that the basis for your recommendation was that this is what the victims are seeking. Are there any victim impact statements?
There are not, Your Honor. I gave both victims the opportunity to make a victim impact statement. Quite candidly, one victim indicated that he did not want to give an impact statement because he didn't want Mr. Hussey to have any insight as to what his life was like at this point in time. So he didn't want to provide that opportunity. The other victim also indicated that he did not feel that he had any type of need to write an impact statement, that he was on board with the recommendation and happy with the recommendation and hoped it went through and didn't see any benefit to writing an impact statement at this point in time. He didn't think that that would suit him in any way.
Okay. All right, so we'll go forward. And not saying at this point whether I'll accept it or not. I have to hear some facts. So, all right, why don't we have Mr. Hussey come up to the witness stand here? Sure.
And Judge, would you like us to stand by him or stand here?
Whatever you prefer.
Okay. Do you want me to go? What? Yeah. You want to go? Yeah.
Mr. Hussey, do you solemnly swear that you will give true answers to such questions that shall be put to you in the matter now and hearing before the court of public God? Thank you. Can I inquire, Your Honor?
Yes, okay, go ahead.
Counsel, do you wish for me to inquire of the defendant as to the proper change of plea?
Yes.
Mr. Hussey, do you wish to change your plea?
No.
Mr. Hussey?
Oh, yes?
Yes.
Yes, I'm sorry.
On indictment number 1983 CR 00194, offense number 001, which charges you with indecent assault and battery on a child under 14 years, how do you now plead, guilty or not guilty?
Guilty.
On offense number 002, which charges you with indecent assault and battery on a child under 14 years, how do you now plead, guilty or not guilty?
Guilty.
On offense number 003, which charges you with indecent assault and battery on a child under 14 years, how do you now plead, guilty or not guilty?
Guilty.
On offense number 004, which charges you with indecent assault and battery on a child under 14 years, how do you now plead, guilty or not guilty?
Guilty.
Your Honor, the defendant has submitted a written waiver of rights and now pleads guilty to this indictment.
All right, thank you. All right, Mr. Hussey,
Yes.
I'm Judge McGuire. I have to decide whether or not to accept your guilty plea. And to do that, I need to ask you some questions. If you wish, you can remove your mask when speaking. You don't have to, whatever you're more comfortable with. Okay. Now, as I said, I have to decide whether to accept your guilty pleas. I need to determine whether your pleas are voluntary, knowing, and intelligent. In other words, I need to be sure that you're doing this of your own free will and that you understand the consequences of pleading guilty. So if I say anything you don't understand, you just let me know. I'll be happy to rephrase the question, or I'll let you talk to your attorney privately, all right?
Thank you.
You don't have any difficulty understanding English, do you?
No.
Okay. And how old are you, Mr. Hussey?
I am 55.
Okay. And how far did you go in school?
I went through 1 year of college.
Okay. And have you been employed?
I have been self-employed for about 35 years as an entertainer.
All right. Have you taken any kind of drugs, including prescription medication or any alcohol today?
I have taken several prescription medications today for my immunosuppressants and that sort of thing.
Yeah. Do those drugs interfere in any way with your ability to understand what's going on here today or to make a free decision about whether to plead guilty?
Not at all.
Okay. Have you ever been treated for any mental, psychological, or emotional illness or condition?
No.
Okay. So as you sit here this afternoon, you're completely able to understand everything and make a free decision about whether to plead guilty, correct?
Yes, Your Honor.
Okay. Now, by pleading guilty, you're giving up certain constitutional rights. So I need to go over those rights with you to make sure that you understand them and to make sure that you are willing to give them up by pleading guilty. So you have a right to a fair and impartial trial, either before a jury or before a judge without a jury. Do you understand that right?
I do.
Okay. A jury consists of 12 individuals chosen at random from the community, and you and your attorney could participate in selecting the jury. Do you understand that?
I do.
At a jury trial, the jury decides all questions of fact and determines whether you're guilty or not guilty. The judge's role is to rule on legal issues and to explain the law to the jury. Do you understand that?
Mm-hmm.
Okay. If you could just say
Yes, sir.
That's just because we're recording it. All right. You could not be convicted unless all 12 jurors decided that the government had proved the charges against you beyond a reasonable doubt. Do you understand that?
Yes, I do.
Okay. As I said, you also have the option to be tried by a judge without a jury. And if you chose that option, the judge alone would listen to the evidence and decide whether you're guilty or not guilty based on the facts in the law. Do you understand that?
Yes, sir.
Okay. You're presumed to be innocent of the charges against you unless and until the Commonwealth proves each element of each offense beyond a reasonable doubt. Do you understand that?
Yes.
At a trial, you would have the right to confront the witnesses against you. In other words, you could face your accusers. Your attorney would have the opportunity to cross-examine those witnesses, and you would have the right to call witnesses and present evidence in your defense at the trial. Do you understand those rights?
Yes.
Okay. Also, you would have the right to exercise your privilege against self-incrimination. In other words, you could remain silent. Nobody could force you to testify, and if you chose to, you could simply sit back and force the government to prove the charges beyond a reasonable doubt. Do you understand that?
Yes, sir.
Okay. Are you willing to give up these constitutional rights by pleading guilty today?
Yes.
All right. Now, by pleading guilty, you're also giving up the right to file any motions in the case, such as a motion to suppress evidence or a motion to dismiss charges. And I think you did file a motion to suppress evidence. And you're also giving up the right to appeal the denial of any such motions. So, in other words, by pleading guilty, you're bringing the case to a close. Is that what you want to do?
Yes, sir.
All right. Now, I have this waiver of rights form, and I'll just ask you if that's your signature. Yeah, if that's your signature on it.
Yes, it is.
Okay. And did you go over this form with your attorney?
Yes, I did.
Okay, so you understand this form sets out the rights you're giving up by pleading guilty today.
Yes, sir.
Okay. Were you confused by anything on the form?
No.
Okay. And are you willing to give up those rights?
Yes.
Okay. Now, I'm sure your attorneys have gone over the charges with you, but I have to ask for the record, have they explained to you the elements of the charges? In other words, what the prosecution would have to prove for you to be found guilty?
Yes, sir.
Okay. Now, as I said a minute ago, I won't decide what sentence to impose until the end of the hearing, until I've heard everything. But I would not exceed the plea agreement without giving you a chance to withdraw and go to trial. Now, you're charged with 4 counts of indecent assault and battery on a child under the age of 14. So I have to advise you that the maximum sentence allowed by law for each of those charges is 10 years in state prison. And a court could impose sentences to run concurrently, in other words, at the same time, or consecutively, one after another. The agreed recommendation calls for me to place you on probation. If I do that, then you'll have to abide by the terms and conditions of probation. Mm-hmm. And if you violate the terms and conditions of probation, after a hearing, if a judge found you violated the terms and conditions, the judge could impose up to the maximum sentence allowed by law on those charges. You understand that?
Yes, sir.
Okay. Also, while you're on probation, in the second year of probation, you earn compliance credits. That essentially shortens the period of probation. In the second year, you earn 5 days per month, and in the third year, it would be 10 days per month. However, if you're found in violation of probation, the judge would have the option to take those credits away and put it back to where it was originally. And also, I have to advise you, because of the possibility that if you were found in violation, you could be in prison, that the court has nothing to say about the issue of parole. That's up to the parole board.
Okay.
Okay. Now, by pleading guilty to sex offenses, you'll be subject to civil commitment. Since the agreement is probation, if you were arrested and incarcerated, found guilty, and incarcerated on another charge, you could then be subject to a civil commitment as a sexually dangerous person. And the way that works is prior to your release from prison, should you be charged with something else and convicted, the district attorney or the attorney general could file a petition for your civil commitment. If that occurred, you'd have a separate civil trial to determine whether you're likely to commit new sexual offenses due to any mental abnormality or personality disorder. If a jury at that civil trial unanimously found that you were a sexually dangerous person beyond a reasonable doubt, then you could be committed civilly for a period from 1 day to life. Now, also, by pleading guilty, you'll be subject to the Sex Offender Registry Act. You may be required to submit information to the Sex Offender Registry Board, you may be required to register with the board, or if you move to other states, you may be required to register with similar agencies in those states. You would have to provide your name, address, and other personal information. You also may have to verify such information and give notice of any change of address or intended change of address. Also, depending on how you're classified under the Sex Offender Registry Board, police departments may be able to disseminate personal information and your photograph and information about your conviction to the public. And I have to warn you that failure to register or verify with the Sex Offender Registry Board is a separate crime, punishable by a separate sentence. Okay. I also have to give you the following warning. If you are not a United States citizen, conviction of the offense with which you have been charged may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. And further, if you're convicted of a crime that presumptively mandates removal from the United States under federal law, and if federal officials decide to seek removal, it's practically inevitable that the conviction will result in deportation, exclusion from admission, or denial of naturalization under the laws of the United States. That only applies if you are not a United States citizen. So with that in mind, do you still want to plead guilty?
Yes, sir.
Okay. Do you have any concerns or questions about possible immigration consequences?
Not at all.
All right. Also, you'll be required to provide a DNA sample to be included in the state DNA database. All right, so I'm going to ask the prosecutor to tell me what facts she says the Commonwealth could prove beyond a reasonable doubt. I'll just ask you to listen to these facts, and I'll have a few more questions for you.
Certainly.
So, Ms. Fowl.
Your Honor, should this case have gone to trial, the Commonwealth would prove through testimony that the defendant, David Hussey, was the leader of something known as the Society for Young Magicians. He was in this role back in the 1990s. He met victim number one approximately in 1994 when victim number one attended a 4-week magic course at the Minuteman Regional High School in Lexington, Mass. The defendant was a teacher at that course at that point in time, and it was then that victim number one learned about the Society for Young Magicians, also known as SYM. The victim at that point joined SYM in 1994 that fall and became a member of that group, interacting with the defendant as well as other individuals. The victim number one would attend monthly meetings and over time started to spend more and more time with the defendant. In addition to being a leader for SYM, the defendant was a counselor at something known as Tannen's Magic Camp. This was in New York. The defendant was a counselor at that camp from 1997 to 2005. Victim number one would attend that camp as well and spend time with the defendant there. When victim number one was approximately 13 years old, he began spending even more time with the defendant. Again, he first met the defendant 5 years earlier when victim number one was approximately 8 or 9 years old. He then, between the time frame of 1999 and 2000, when he was 13, started to spend time with the defendant and started staying over at the defendant's residence in Rockland. He would do this where the defendant resided with his mother. The routine essentially would be that the victim number one would go to the residence, spend time with the defendant. They would stay up and watch magic videos and study magic for a significant amount of time until the wee hours of the morning, usually until sometime after midnight. At that point in time, they would go to the attic where the defendant's bedroom was. The victim one was able to describe the defendant's bedroom as having a single bed and a couch within that room. When the defendant would go to bed, he would ask victim number one for back rubs, and he would reciprocate those back rubs. He would also ask victim number one to do things such as walk on his back while they were in the bedroom. Victim number one would describe that the defendant, Mr. Hussey, would touch victim number one's buttocks, inner thigh, thigh area, and his genitals underneath his underwear after starting those back rubs. Victim number one was able to describe 2 distinct instances where the defendant would reach under victim number one's undergarments and place his hand on victim number one's male genitals. Again, this was at the time of the back rubs. Victim number one was adamant that he never touched the defendant anywhere except the back when the defendant would ask for back rubs. Victim number one described that he felt as if, in his words, David, the defendant, had power over him and he couldn't wait for those times to be over so that the victim could go to bed. Victim number two in this particular case indicated that he joined SYM in approximately 1996 when he was 8 years old. Again, the defendant was still a leader of SYM at that point in time, and that's how victim number two and the defendant met. Victim number two started taking lessons from the defendant when he was approximately 9 years old, and when he was approximately 10 years old, he started going to the defendant's residence, again, that same residence in Rockland at 41 Norman Street. While at the defendant's residence, they would practice magic and watch magic videos, again, well into the night or early morning hours. He believes that between the ages of 10 and 14, he stayed over at approximately at least 10 times. Victim number two was able to describe that when he was between the ages of 11 and 13, that he would also stay at the defendant's residence when the defendant had moved into Canton. Victim number two was able to describe that while at the Rockland residence, again, very similar to victim number one, victim number two described that the defendant would ask for back rubs and that the defendant would give victim number two back rubs. Victim number two described that he would be laying on his stomach or his back on the defendant's bed, and the defendant would start to rub victim number two's shoulders, his back, his buttocks, his thighs, his inner thighs, and he would graze over his genitals and touch his genitals. Victim number two indicated that the defendant never actually, in his words, quote, grabbed the genitals, but would touch his genitals and his buttocks. These allegations started, again, 1998, 99, 2000 timeframe. Victim number one continued to have some sort of relationship with the defendant. I would suggest a friendship with the defendant over the years. It wasn't until 2018 when these allegations came to light that they became known to the Commonwealth. Victim number one actually told victim number two first about the allegations, and both of those individuals came forward. The individuals came forward with regards to the allegations when they saw a social media post on Facebook. It was a GoFundMe post. The defendant was about to undergo surgery or was undergoing surgery for medical issues, at which time they saw the GoFundMe post and they had concerns about other juveniles who may be contributing to that. Victim number one indicated that he had previously contributed to a GoFundMe page for the defendant several years earlier for a different medical procedure. Victim number one, in fact, indicated that he had actually had the defendant stand with him and be his best man at his wedding. Victim number one indicated in the interview that he had also received gifts from the defendant, one of the gifts being a CD that the defendant would play during the time that the sexual assault would occur. Victim number one believed this to be the defendant's attempt to remind him of what had happened between them and to continue to exercise control over him. Starting in about 2016, victim number one was able to start to separate himself from the defendant more and more until he saw those posts in 2018. After those posts in 2018, victim number one spoke with other individuals, and eventually friends of the defendant went to visit the defendant at the hospital after having information about these allegations. One of those individuals who went to speak to the defendant was a female by the name of Miss Dillies. She came and testified, gave statements to police, and I would suggest that she would testify at trial that on or about September 12th of 2018, she was staying with the defendant at the hospital, and she was asking the defendant about the allegations that had been made. The defendant repeatedly tried to determine who had made those allegations at that point in time. She would not tell him, but she would talk to him about the back rubs that he had provided to young gentlemen over the years, at which time the defendant made a statement along the lines of, quote, "I may have done something inappropriate. Maybe I have done something to cross the line." He also stated, "I'm not going to come out of this. I'm not going to survive this." It was unclear at the time if the statement of "I'm not going to come out of this, I'm not going to survive this" was related to his medical procedures, to the allegations, or to both. But Ms. Dillies, who had known the defendant for a significant amount of time, believed that it likely was with regards to both the surgery and the allegations. Those would essentially be the facts, Your Honor.
All right, thank you. Now, Mr. Hussey,
Yes.
By pleading guilty, you're admitting that the facts of the offenses are true, that is, touching the victim's buttocks and genitals. Do you understand that?
Yes, I do.
Okay. Are those facts true?
Yes.
Are you disputing any of those facts?
No.
Okay. Now, have you had enough time to talk to your attorneys about your decision to plead guilty?
I have, Your Honor.
Okay. And I'm sure they have explained your options to you, including the option to go to trial. Is that right?
Yes.
Okay. Are you satisfied with their representation of you?
Very much so.
Okay. Are you confused by anything that I've said today?
Not at all.
Okay. Are you pleading guilty voluntarily?
Yes, Your Honor.
Has anybody made any kind of threats or promises to get you to plead guilty?
No.
Okay. And you understand your rights and the consequences of pleading guilty?
Yes, sir.
Are you pleading guilty because you are guilty and that's what you freely decided to do?
Yes.
All right. Okay. I find that there is a factual basis for the charges. I find that Mr. Hussey is not under the influence of drugs or alcohol except for prescription medication, and the prescription medication does not impair his ability to make a voluntary, knowing, and intelligent choice as to whether to plead guilty. I find Mr. Hussey is not suffering from any mental illness or abnormal mental condition, that he fully understands his rights and the charges against him, and that he's made a voluntary, knowing, and intelligent decision to waive those rights and plead guilty. Ms. Fowl?
Your Honor, Commonwealth would move for sentencing if Your Honor is inclined to accept the plea. Again, the sentencing recommendation before you, the Commonwealth agrees with the court that it is a very lenient sentence, especially given the allegations, the defendant's position of power by way of the magic camp, and I would suggest the implication of the amount of grooming based on when these victims met him versus when the sexual assault took place. But again, the Commonwealth asked for this plea agreement, asked for this sentence of probation based on the wishes of the victim. victims. We have spoken to both of them extensively with regards to what it is to testify, what it would be to testify, the amount of stress that it puts on them. They've expressed the amount of stress that it puts on them. The Commonwealth has informed them that certainly we would do everything to alleviate that stress, meet with them as many times as we needed to leading up to trial, and make it as easy of a process as we could. But certainly both of them have indicated that there really is no easy process for them to relive everything that took place with regards to Magic Camp and their time with the defendant. I would suggest, based on the facts and based on what both of them have said, this was certainly somebody that they trusted, somebody that had really become part of the family, so their level of betrayal is significant. And to ask them to relive that is, I would suggest, certainly a very big ask, especially based on everything that they have told the Commonwealth with regards to how they feel about having to testify, the nervousness that they have about having to testify, the downright fear that they have of having to testify, all while knowing that frankly is a risk. There is no guarantee with regards to a bench trial or a jury trial. That has been explained to them. Their biggest concern is making sure that other individuals, male or female, don't have to go through what they went through. And they have asked repeatedly, is there a way to have any type of guarantee? Certainly there isn't, but the best guarantee that the Commonwealth could give them is by having a guilty plea enter and having the defendant register and having those guarantees in place that in fact it is a guilty finding on his record. There is a registration requirement. And so for those reasons, based on their wishes, based on their desires, based on the facts of this case, I would ask that you accept the sentence presented.
All right. Thank you. Mr. Corvo or counsel?
I'll speak, Your Honor. Thank you. We're asking you to adopt the agreed upon plea. I just want to let you know about Mr. Hussey. He had been self-employed as essentially an entertainer. He's a professional magician. And what he was able to do with his career was he worked locally, he worked nationally, he worked for corporations. He'd be somebody who'd do a corporate party. The Society of Young Magicians, he would meet in the public space in Boston with children and their parents. He's taught at the Magic Camp. He's had a fairly successful career. And the timeline of this case is the disclosures came out in September of 2018. Just one little correction to the facts, and it does not affect the plea or the factual basis of the plea whatsoever. The way it came about is Ms. Dildy spoke to victim number one, whose initials PD. She didn't know, he didn't disclose to her what the conduct was. He just said it was, inappropriate, and my client made the statements, and then essentially what happened was he wasn't charged until January of 19, and the Society of Magicians, different magic groups were notified nationally. It went across social media, there were emails. He was given a cease and desist from the Society of Magicians, different groups. His career essentially ended. Anybody in the magic industry, which is a rather, I've learned, small community nationally, was aware of this. At the time, he was, complaints were taken out. He was charged in district court. And since that time, he's been unemployed. His stage name was David Oliver. He felt it was easier to pronounce. And he's been able to find work. He's been trying to find work the entire time. People Google him, and you put David Hussey and just put the words David Hussey, and in this case comes up. Currently, he's had severe financial difficulties, health issues. Our social service advocate in our Quincy office, since Attorney Harold and I both used to work in Rockland CPCS, since the case has gone on, he now works in Boston. I work at the Quincy office, and our social worker in Quincy, Kristen Crawford's, been working with Mr. Hussey to try to get him to apply for SSI, gathering medical records, and essentially he's living on a basically weekly basis at a motel in Rockland, surviving on donations and selling. I did file a motion to waive fees with an affidavit, which I'm asking you to look at, but I put in there that he sells personal property. He's literally sold his magic props, books. He doesn't really have anything of per se value, but might be valuable to other people. He's been selling those over the past several years. He had been living with a cousin, I believe, Mr. Hussey, right? He was living up in Watertown, then in Bridgewater, and he's got no one to take him in. He does have supports, but no one to live with. He's well aware of the seriousness of the probation, the requirement of SORB registration. He's been anxious about finding out how that works. I reached out to, if the court were to give him probation, I did find out who his probation officer would be and sort of check what does he do, when does he register, does he do it? If they believe he does it through probation first at the first meeting, but that will provide, I think, restrictions on him. He's got the condition to have the sex offender evaluation and recommended treatment. And his health issues are fairly serious because the cancer is fairly aggressive because of the immunosuppression, more so than if somebody else got skin cancer. And that's been a major concern of his. He's been very forthright with us, sharing medical records. I think I said earlier the medical records of the prior surgery was part of the case. So for those reasons, Your Honor, I'm asking you, I was going to ask, and we had talked about this, the ADA file had allowed me to argue to have the probation terminated after 2 years, and then I remembered about the compliance credits. Essentially, what Your Honor explained to him is it's about 6 months if he's compliant. So I'm not going to, I still have the court maybe to consider that, but at this point it appears if he's got the incentive to do well and have the probation end at 2.5 years. My motion basically asks, given that he literally has no funds and he's been trying to work. I can tell the court that we've been working with him on this. It's unlikely he's going to have to go on SSDI and try to get some housing. And housing is going to be, at age 55, difficult for him to get due to the sex offender registry status in itself. And he's well aware even if he violates probation with no new offenses, they can still go forward on a sexually dangerous person petition if he's incarcerated, which he no way wants to ever see happen. And he has been compliant with his probation officer, Justin Yon, and Brockton, and there's been no issues whatsoever, not even a dead battery or anything like that. So for those reasons, I'm asking the court to accept the joint recommendation.
All right. As I mentioned before, it's a more lenient sentence than normally would be given for these particular charges. However, I will accept the recommendation and accept the plea. And pursuant to General Laws, Chapter 265, Section 41, my reason for imposing a sentence that does not involve incarceration on these charges, well, there are several reasons. First and foremost, the victim's feelings about it. Second, the fact that Mr. Hussey has no prior record or subsequent record. These are very old offenses, 20 years old. He was not convicted of any crimes before that or after that. I think the conditions will put into place some safeguards for the community. And also having in mind Mr. Hussey's serious health problems. So I'll accept it. On indictments 1 through 4, I'll impose sentences of 3 years probation to run concurrent with the following conditions: to register as a sex offender, to participate in and complete a sex offender evaluation, to enroll, comply with, and complete any treatment deemed necessary after the evaluation, to stay away from and have no unsupervised contact with children under the age of 16, to refrain from seeking or obtaining any employment, career, income, or volunteer opportunities that would put him in contact with juveniles under the age of 16, and to stay away from and have no contact with the named victims in this case. Did you get that? And I'll allow the motion to waive the fees.
Thank you, Judge.
Yes.
Right, good luck, sir.
Mr. Hussey, in consideration of your guilty plea on docket 1983 CR 00194, offense number 001, 002, 003, and 004, the court places you on probation for the period of 3 years. Those to run concurrent with each other. You are subject to the following conditions. You are to register as a sex offender, participate in complete sex offender evaluation. You are to enroll and comply with and complete with any treatment deemed necessary subsequent to that evaluation. You are to stay away and have no unsupervised contact with children under the age of 16. You are to refrain from seeking or obtaining work, career, income, or volunteer opportunities that will put you in contact with juveniles under the age of 16. And you are to stay away and have no contact with the named victims in this case. Do you understand those conditions, sir?
Yes.
Thank you. Mr. Hussey, the court waives all of the fees associated with this case. It would be a $90 victim witness fee, the $65 per month information supervision fee, the $110 DNA fee, and the $150 legal counsel fee, which was previously imposed. Those have all been waived. Thank you. You may please go downstairs and second with probation.
Thank you.
Thank you, Your Honor. Thank you, Madam Clerk.
Thank you, counsel.